Hello, everyone. Welcome back to another episode of Legally Speaking with Rest the Case. And today we have with us Advocate Taranjit Singh from Mumbai. He has over 15 years of experience in the legal field, and his specialization ranged from commercial, civil to technology law, cybersecurity, and more. Welcome to the show, Advocate Taranjit Singh. How are you doing today?
Thank you, Ankita. Thanks a lot. Thanks a lot for inviting me. And I hope that today's discussion will benefit the viewers, whoever will be watching us.
Yes. So today's topic of discussion is the three new criminal laws that are going to come into effect from 1st of July 2024. And today we'll be discussing more about what it means for the people and the judiciary system. So beginning with, why has the government introduced these three new laws?
Okay, so basically this is a question of debate. Many people who did not want it, they have said openly in medias that these kind of laws were not required because the present laws which are there, Indian Penal Code, CRPC, Indian Evidence Act, they are sufficient. The entire system is running well. But why is it that the government is suddenly introduced? Is there some thought behind it, etc., etc.? But when I view it from the perspective of a legal professional, I see that there is a history. Whenever there is a law, after passage of sufficient time, there is definitely is a requirement to repeal the old ones and replace it with the new ones, which should bring the clarity, which should keep it up with the present scenario, what exists, the social economical factors which are existing at that point in time. Because we have seen that when there is an old law, there are a lot of terminologies which are used in that law which you are not even aware of. Like being a student of law, when I first studied Indian Penal Code and CRPC, which were as old as 1860, there were many terminologies like wherein they would mention the presidency towns. As a kid, till the time I did not reach the study of law, I had no idea that this kind of terminology would be there. So when the new generation is going to read this new laws and try to assist the legal system, they will not have to deal with those kind of situation. Of course, once these laws will grow old, they will also require to be replaced and repealed. And the only question remains that whether it has been done well or not, and which only time can say. We can only contemplate. Yes, after reading, we can have certain views. But when it is law, it is always the implementation of law which is more important criteria. You can write it very well, but how it will be interpreted, how it will apply to a situation, and how it will benefit the entire community, that becomes the key criteria.
Yeah. So yes, a few days back we were discussing about these, like a part of these laws about the death penalty and everything else. So for the audience, can you tell us in simple words what all these three criminal laws are actually, which
Yes,
will be
definitely.
implemented?
See, first of all, not all three of them are criminal laws. BNSS, Bhartiya Nagarik Suraksha Sanhita, and Bhartiya Nyaya Sanhita. These are two criminal laws. However, Bharatiya Sakshya Adhiniyam is Evidence Act, which will apply to both the proceedings, civil as well as criminal.
Okay.
Now, this Bharatiya Nyaya Sanhita, which is repealing Indian Penal Code, and Bharatiya Nagarik Suraksha Sanhita, which is repealing the Criminal Procedure Code. There is not a very big difference when you come to the present practice which we are doing in the courts today. But yes, it does streamline a lot of things. It does streamline some of the difficulties which we are facing. It does bring in it does not address some of the challenges which are already there. That is where a lot of critics say that if you are going to bring something new, then why have you not considered those challenges which are already existing? Why you're not answering them? But then it remains a matter of debate because there are multiple agencies, lot of stakeholders which get involved when these kind of laws get enacted. So speaking about IPC, Bharatiya Nyaya Sanhita, it completely reorganizes the entire definition of, doesn't change the definition of it, reorganizes them in the sections. So you will see that old section where you would say 420 is something cheating and etc. You will find that 420 cheating doesn't exist. It is something new, but then it has retained the definition. It has included lot of cyber crimes which are happening. It has allowed the technology to come in and assist the administration of justice, etc. When it comes to CRPC, again, there also the main important criteria is that the electronic evidence and the procedures of attending a court proceeding through video conferencing, which is already there, has been more streamlined. Then there is a metropolitan areas, metropolitan magistrates, etc., which were the old systems. They have been replaced, because earlier it used to be that there was 4 presidency towns, and only there the requirement of metropolitan magistrates were there. Now so many class B cities are developing into metropolitan areas and growing day by day. So having 2 different kind of nomenclature for the similar kind of roles, etc., has been removed. So simplification is definitely evident from the face of it. Simplicity is evident from the face of it. More bend towards the inclusion of technology is evident. However, as I said, that it is the implementation which will be the key to it.
Yeah, right. So how do you think this will change the legal landscape of the country or the judiciary system?
First of all, it is ideally going to remove a lot of ambiguities which are there. Like if you see that when a case is prepared, even happens, we talk a lot about case laws. We say that there is a precedence existing, there are certain case laws which are existing. So once these new kind of a draft is coming in before us, and it has already taken care of a lot of precedences which are already existing. So instead of reading something else, then interpreting it something else, that kind of a scenario will reduce. It will not completely go away, but it will reduce, because while drafting, while rewriting, they have tried to take care of this fact that there are certain precedences which are existing, which are as per the present scenario, as per our community's requirements. So accordingly, they have included that. So that makes it more simpler. Like for example, if there is an offense for which you have been charged, and you just go and Google that, I have been charged with this offense, what this offense is, and you read it, and then you are suddenly having certain, set of opinion that, okay, it is this, I have not done this particular thing, so I will not be charged by this offense. You get that, pseudo feeling. But later on, when you reach the court or the forum, there you see that there are some old judgments, there are some discussions of courtroom, some precedences which will redefine the entire thing, what you read and what the court is going to consider. So those kind of things will reduce. That is the first thing. Second is procedurally, it is going to be little more. It is expected, and it seems that it is going to be more simplified way of doing things, with old forms, old terminologies, etc., being removed, and the latest one which are currently in use being given the sanctity that way.
Right. So like it will be more streamlined in the process and specific and simple for people to understand when it comes to.
Yes, definitely. But then how streamlined is the matter of experience. But yes, when it comes to the reading of the book and understanding the enactment, then yes, more simplification and more to the current. That is what I would say.
Yeah. So now that we have discussed about these three new laws that are going to come, so why do you think it took this much time to be implemented like now, and why not before?
Yes. So here I have a very personal opinion. My opinion is that in order to do a drastic change, you require a government which is stable, the government which wants to do it, and who has got the majority in the house. Because it is so that in democracy, the government which is there, whatever it does, they will get criticized, and there will be a lot of opposition which they will face. The opposition will always feel that if they are doing a good job, the present government, then let this government go away and we will do the same thing. So that is one of the reasons it took time. Secondly, there was not a real requirement, there was no real demand for these bills and laws to come in, because already the system which was going on with the precedent set, with the lot of amendments which had taken place, had actually kept it abreast with the present system. There was no major challenges which were happening. Courts were functioning well. So there was no real requirement. So that is what I would say. But however, since this particular government had this in their agenda, since they wanted to make the real kind of impact, since they do have a feeling that after the implementation of these laws, whatever they will do for the country will be good, I think that is the reason why it came now.
Yeah. So now that it will be implemented on 1st July, after it has been passed, how much time does it take to be actually implemented in the different cases and everything else?
Understood. See, rather I would say that when it was enacted, that is the time when it should have got implemented same time. The reason it has not got implemented is because the question you asked, that how much time it will take. So ideally that how much time from the date of notification, that is the time it should take. That is the time for everybody to read it, understand it, debate over it, and try to see. So once the act is passed, it is the notification date from which it will actually take effect. So once it is notified, which has been done, that from 1st of July it will come into force, then there is no further delay. Everybody will have to follow it. The police will register all the offences in accordance with the Bharatiya Nyaya Sanhita. Whatever actions they will take in accordance with the Bharatiya Nagarik Sanhita. And when we will go to the courts, we will produce our evidence as per the Bharatiya Sakshya Adhiniyam.
Right. So now these are like complicated terms in one sense. So how will it affect normal people or the common man? Like, what should they know about these laws?
See, law as such by nature has been little complex. Though people are more aware now, people do read, but the complexity still remains. So for the common man, the best thing that has happened right now is that the old era systems, old era terminologies, which I already mentioned, rather I'm repeating them, which has gone. That is the first kind of assistance which they have got, that when they read, they will immediately understand. That is the first thing. Second thing is that it's in the present scenario, we face it in the courtrooms, that it becomes very difficult, even if there is a very good electronic evidence in the form of a telephonic recording or in the form of some WhatsApp communication, and that is the only evidence which you have. It becomes very difficult to press your case through that. There are some old kind of primary evidence defined which is required to press your case. They don't. The courts don't just rely on the electronic evidences, though it is not the right statement universally. Some courts do, some judges do understand, but then there is this lacuna is always there. At times it becomes very difficult. With removal of that, if you are a genuine litigant, if you have a case and you have a good evidence which is in the form of electronic evidence, with introduction of this Adhiniyam, it is going to be accepted by the court and a judgment may be passed in your favor.
So, previously it wasn't considered as strong as an evidence, like video recording.
Yes, it was in a transition phase. There were ambiguities. At times it was accepted, depending upon how it has been presented. That is the more important factor, how it has been presented, how much is it relevant, what is the fact. But there was always a small ambiguity whether it should be accepted or not. That whether ambiguity is now going to go away and it was going to become that why it should not be accepted.
Right. So this will make the case more powerful, because now, as you said, the technology has a very big part to play in cases, because there's these video footages and audio footages and chats and everything. So I think that's a very strong step that that is taken.
I'll just make a common example. For example, if you have a witness who is giving a statement against you in a courtroom, and you want to confront him with some of his old recording, it was very difficult to confront him. But today with this Adhiniyam, if you will confront him with his recording wherein the statements given by him are totally different than what he has been stating in the court, it will become very powerful tool in the hands of the opposing advocate, and he will be able to undo with that particular witness.
Yeah, definitely. So these are like pretty good law, like pretty much that was there in the agenda. So what kind of challenges can come up with these new laws? What do you think?
Yes, so there will be I don't think there will be any very, very new kind of challenge. The challenges which are there with the law will always remain. Somebody will interpret it in the manner in which they want to. For example, when there is a criminal proceeding, the police will interpret it in a manner that police will have more power. The courts are going to interpret it in a manner that courts will have more power. The advocates will interpret in a manner wherein they will try to show that which of the agency has not acted as per the law. So that kind of challenge will always remain. This particular law is not the perfect law. It still holds. The precedences will have to come in. It will take some time. A lot of cases will have to reach till Supreme Court to get the right interpretation. So these challenges will come whenever there will be an ambiguity. It is going to take considerable time to get decided. They will have to reach at least up to Supreme Court, where the interpretation of the law can take place. Of course, it can happen in
Yeah.
High Court also, but then whosoever agency will be defeated will challenge it in the Supreme Court. So finally, it will come from there. So a new precedences will have to come in to make the right interpretation in the interest of the community altogether.
Yeah. So, are there any challenges on the global level that these laws might face, or any criticism that they might face?
After studying them generally, I am of the view that it is more acceptance which will come in. International community will understand it better. They will find that the kind of laws which exist in their country, it is quite similar to that, especially when speaking about the criminal offenses. So like in as you said initially when we started the discussion, that the type of punishments, so type of punishments remains same, but there is one new terminology introduced, which is the what we say, community work, which has been introduced. So for small
Yeah.
offenses, correct.
Right.
So all those things are coming in, which are akin to what international best practices are. So I think introduction of these laws are going to give us little more edge. People who are coming from abroad will be able to understand, because whenever you go to a country, you at least try to understand some of the basic existing laws, what really happens over there. So that particular inclusion, feeling of more understanding will definitely be there.
So, coming to the final question, I would like to know your opinion on these new laws. Like, do you think it was like required in this judiciary system, or what else do you think about it?
Personally, I feel it was definitely required, because I believe that it is the basic act, the bare act, which should speak, clarify, and keep the things in the right perspective there and then. There should not be many scenarios wherein you have to do interpretation, where you have to read down a law, where you have to go to the Supreme Court to make the right kind of interpretation. So with these laws coming in, it gives a feeling that those scenarios will be reduced to an extent. Now, when do this really happen is when one of the agencies starts to take advantage of the power which these laws are giving them. If they will behave or act in a manner which is which does natural justice, then I don't think any court will read those provisions down. Rather, they will empower them more. Further, if the courts are infringing into the powers of the investigating agencies, then there is an issue of that sort, wherein the agencies will have to push through they will not be able to operate well, they will not be able to bring in justice, they will not be able to control crimes.
Yeah.
All in all, this their reading of these acts definitely provides a lot of confidence, and if it is implemented in the same spirit and keeping in the the good of the community in mind, the objective will definitely be achieved.
So I think this was a very insightful talk we had related to these 3 new laws. So thank you so much, Advocate Taranjit, for joining us in this new episode of Legally Speaking, and we hope you enjoyed it.
Thanks a lot. I'm always looking forward. I hope that sometime we will have more technical discussions on this. Let the law get implemented. There will be challenges, and we will discuss them.
Yeah, definitely. So we are looking forward for more such discussions with you. So until then, thank you so much for joining. Thank you everyone for watching this, and we will see you all soon next in our next podcast. So thank you so much.